Good evening.
Good evening.
Hello, good evening.
Good evening.
Hi, Alex.
Hello.
Hello, can you hear me? Oh, yes, that's working. Good evening, everybody.
Good evening.
Good evening, Attorney Dizon.
Good evening.
Maybe charging in the charger.
Where's the charger?
In your office.
So we have 2, 4, 6, 7 people right now. So maybe you can wait a little bit more. I'm not sure.
Maybe another 5 minutes.
5 minutes, then we
Yeah,
can start.
please.
Okay.
Thank you.
Hello, Miss Marina. Hello, Brother Alex.
Hi. Hi, Steve.
Hello.
Hello.
Very good yung mga brothers
Gabi sa inyong
natin.
lahat.
Magandang gabi din po sa inyong lahat. Thanks for joining.
Oh, thank you for inviting us. Thank you. Thank you so much.
You're welcome.
I'm talking to a meeting. We have a meeting.
That's okay. Okay, let's go upstairs, kids.
Okay, there's another one coming in. Hello, Javier, Anna, Teresa. Is this just one person? Like 3 names there. And welcome, Steven. Saulog.
Yeah.
Kayo po bang may-ari ng Saulog, ano? Bus?
Hindi po.
Okay, Mr. Randolph Datu is joining right now. Ito ba si Mr. Randy Datu? Randolph ba siya?
Yes, si Randy.
Okay. Oh, there's another one, Weldon. Okay, let me admit them.
I guess we won't have any.
And Miss Leah Takas is here. And Vienna. Hi, Vienna. Vienna Olga Parse, right? Oh, her audio is still connecting. I think she's based in the Philippines. Okay, we have Maria Jadel. I'm just reading the name to acknowledge the people who are joining right now. I guess we have more people now, not a member of FAATx, so that's why.
Yeah, in-invite ni Alex.
Make sure that whatever got open.
So once we start, I'm gonna have to mute you all, but there's no noise in the background. Connie is here. Connie Espelita is joining us too. Okay, we're just waiting a little bit more for others who are still trying to join. So I guess there are more people who registered than those who are already here right now. Let's just give them time. Remember, we have the so-called Filipino time. And also the challenges of online, webinar. So there's always a technical issue that could come up at any point in time. So, and this is what I learned in all the instances, or in all the Zoom meetings that I did for over a year. There's always that, and even during my hearing time, even during the hearing in front of a judge, there's always that technical difficulties. And so the judge is also aware of this and very, very nice and very patient. So yes, actually technology is testing our patience, I believe. And not as adults, but also children, because they went on online learning the whole year. So their patience were tested as well. All right, more people are coming in. So I'm just gonna click on admit. I'm not sure if I started the presentation, if I can, I think it will still show if there's somebody trying to join in. It will show, so I guess I'll just have to click on admit. All right, it's 7:06. How about 4 more minutes? So let's start at 7:10. All right.
Thank you for your patience, Attorney Dizon.
No, thank you for all your patience. We're all waiting here all together.
Yeah.
We're all in the same boat.
Thank you.
I guess we have a toddler in the background. I can totally relate. Oh, there's somebody trying to join in, but it's only showing a number. So I'm just gonna go ahead and admit. Justin Ferguson is saying, "Hi everyone, I'm not a cat. I am a human, a human." I have 2 more minutes and we're gonna start. So I will start sharing my screen. Let me see if my PowerPoint is ready.
Maybe we can ask everybody else when you started the webinar, maybe everyone can mute themselves if they're not talking so that we don't have any feedback.
Actually, Attorney Dizon will mute all of us.
Yeah, but thank you for reminding us. We will definitely do that.
Thank you.
Okay, let me start sharing. I'm gonna look for my PowerPoint.
Thanks, Connie.
Okay. All right, Diana joined us. So can you all see my PowerPoint?
Yes.
All right, thank you. So I make it a screen. So I think it'll show if somebody's trying to join in. So I'm just gonna go ahead and click admit, hopefully.
Before we begin, I would like to personally introduce you. Can you hear me?
Yes, I
Can you hear me?
Can you hear me?
Yeah, we
Okay,
can hear
great.
you.
All right, great. Yeah, we can hear you too.
How
A
about
lot of
me?
people are muted, so they cannot respond, I think.
I see.
But can you hear me? I would like to introduce first our attorney, Aileen Dizon.
I can hear you. So
Okay.
I guess we all can hear you.
All right. Good evening, everyone. We are really very fortunate to have Aileen Ligot Dizon as our speaker tonight. And first, we would like to thank you for accepting our invitation to be the presenter for this meeting. Uh, Aileen Dizon is an attorney admitted to practice law in all state courts of Texas and a lifetime member of the Integrated Bar of the Philippines. She handles divorce law cases, real estate and wills trust probate law cases, guardianship law cases, and family-based immigration cases. Aileen is concurrently pursuing her doctorate in education, in professional leadership, and educational administration at the University of Houston main campus. She is a graduate of Master of Laws at the Southern Methodist University Dedman School of Law located in Dallas, Texas, and Master of Education in Educational Leadership, Administration, and Supervision with Principal Certification at the University of Houston in Victoria. She completed her baccalaureate studies in education at the University of Houston downtown, and she is a graduate of the University of the Philippines and the University of Cordilleras College of Law. Ladies and gentlemen, I'm honored to introduce to you and present to you Attorney Aileen Ligot Dizon.
Thank you, Tito Bert, for such a kind introduction. I'm sorry, I noticed that my screen right now doesn't have the option for me to mute everybody. So I'm trusting that everybody will mute themselves. So I didn't realize that once I started sharing, it will not show that option. But yeah, so disclaimer and housekeeping before we start. This presentation is intended to help everyone to understand the specific area of immigration and family law in Texas. The material that I prepared here is only for general information, informational purposes only, and does not constitute any legal advice. So no person should act or rely on any information in this presentation without seeking the advice of an attorney.
Immigration developments.
Now, since we are in it's supposed to be a webinar, but we're not using a webinar feature of the Zoom. Please just use the chat box to type your questions, and questions will be read and addressed at the end of the presentation. Let's keep the question related to the topic that we're discussing right now. And the reason why I say that is because this is really a very wide topic that we are trying to discuss in just an hour. As a matter of fact, one concept here can be discussed in more than 3 hours, but all of them is just in 1 hour. So we're gonna try our best to just go over each one of those big topics that actually are related to immigration and family law at the same time. Now, please be reminded to mute your microphones at all times. We're all professionals, so we know how to handle ourselves in a Zoom meeting like this. Thank you very much. And so we will start our presentation. Okay, and there you go. So tonight I will be presenting about the intersection of immigration and family laws in Texas and related immigration developments. There are three objectives that I prepared three objectives here. The first one is to understand why family law is relevant to immigration law. The second one is to learn about the effect of divorce, annulment, and family violence on your immigration status, and to learn about related immigration developments. There's a lot, so we're just gonna pick some of the immigration developments that I think we should be talking about given the time. Okay, so here we go. The first question I would like to ask everybody is, why is immigration law relevant to family law? Let me give you 5 seconds to think about that. 5, 4, 3, 2, 1. Yes. So many US citizens do not understand the immigration role that one's citizenship status plays in the family law context, such as the ability to marry, divorce, annul a marriage, or obtain custody. Well, here in Texas, we don't call it custody, we call it conservation, conservatorship of children, and also the support, financial support from another person. Um, citizenship carries many benefits within the family law context. So let's go to the next slide. Now here, I'd like to address some terms that we might be using or you might be hearing from me over this presentation. So that before we dive in, let's go ahead and talk about this, a little bit of these terms. So the first one is non-immigrant. So when we say non-immigrant, we're talking about a foreign national who is or who holds authorization to be temporarily in the United States for a particular purpose, usually on a visa. So they're not immigrating here, all right? That's why it's called non-immigrant. So at the end of their visa, they have to go back to their country. They have to leave or depart the United States. The other term that you probably already heard many times is the word immigrant or lawful permanent resident. So we commonly know this one as green card, So green card recipient is defined by immigration law as a person who has been granted lawful permanent residence or residence in the United States. So sometimes we call them LPRs. LPR may apply for US citizenship after meeting certain eligibility requirements like number of years and of course the other documents that you need to submit to the USCIS. The other term here that I'd like you to pay attention is the word refugee or asylee, although we're not really going to be digging deeper or deep into the issue of refugee or asylee. I just want to include that term because sometimes it's the entire family who is trying to seek asylum in the United States, or they are coming into the United States as refugees because there's a war in their country or they're being persecuted in their country. So they need to seek refuge from the word refuge in the United States. The other term is visa overstay, where a foreign national who has overstayed their authorized time here in the United States, that's why we call it visa overstay. He or that person is subject to, or may be subject to detention, removal, or visa cancellation, and even bar from re-entry in the United States. Could either be 3-year ban or 10-year ban rule will apply. Visas are issued for specific purposes and time periods for reasons such as work, tourism, education, or medical care, something like that, something in that context. Now, the word undocumented, we hear this a lot. When we say undocumented, we are talking about foreign nationals who enter the United States or who is present here without authorization, or they did not go through the inspection process. They did not enter into the port of entry, like when you go to the airport, there's a CBP there. So they didn't go through that inspection. They didn't have documents when they came into the United States. So that's why they are simply called undocumented. Now, the other terms that we will be talking about today is a spouse, but I will explain that later on because a spouse has different meaning, similarities and differences as to how we define spouse in terms of immigration law and family law. So I think that is also important for us to know who is a spouse under immigration law and who is a spouse under family law. And the other term, of course, is the child or children. Although we will not talk more about the child custody and conservatorship tonight because it's a big topic, and I figure out that it's really not going to fit into our time frame. Maybe for our next webinar, that could be an entire topic because it encompasses a lot of aspects. because there's like the aspect of international adoption or childbirth here and so many other topics there. But I just want to include that one because at some point we will be talking about the child or children of immigrants. Okay. So now a little bit of statistics, and the reason why I included this one is because it shows how important it is for us to understand the intersection of immigration and family law here, especially in Texas. Now, the reason why I put the word Texas, by the way, in our presentation is because immigration law is federal. So anybody, any attorney across the nation, across the United States can actually handle immigration cases. But when it comes to family law, that is based on state law. So we have a different family law here in Texas, different in Washington or New York. So we have different laws. And as a Texas attorney, my only jurisdiction is, of course, family law here in Texas. That's why I have to make sure that I have to explain that, because I know that we have a guest guests tonight that are not from Texas. So yeah. Okay, so according to, this is the latest that I've got from the website from the Department of Human Services. In 2017, out of all those who were granted lawful permanent resident status are these two big categories here. One category is immediate relatives of US citizens, which is 45.8%. And the other category of admission is family-sponsored preferences, and that's 20.6%. So that's why it's very important, because there's a lot of immigrants who are coming over here and changing their status into lawful permanent residents, and later on will adjust to U.S. citizenship. I mean, will naturalize to obtain U.S. citizenship. So, and that's big. There are immediate relatives and family-sponsored preferences. So we're going to be talking about those two big categories. Okay. All right. So there we go. Family-based immigration. Let's look at an overview of how family-based immigration works in the United States and how you may be able to, or how we, attorney and all the other relatives who are U.S. citizens here in the United States or LPRs here in the United States may be able to help your family or our family abroad to obtain permanent residence here or green card. So we have, all right, there we go, the petitioner and the beneficiary. So the petitioner, of course, family-based immigration requires the participation of these two. We have to have a petitioner and, of course, beneficiaries. A petitioner must be a U.S. citizen, that's right there. To be a petitioner, you must be a U.S. citizen or lawful permanent resident who wants to sponsor a foreign family member for a green card. And the beneficiaries, or the beneficiary, is the foreign family member that wants to, or who wants to obtain a green card, or wants to come over here and immigrate and obtain green cards. In some categories, the beneficiary may have a spouse and children that qualify as derivative beneficiaries. So that's why usually it's family-based. So for example, if one person immigrate here and obtain citizenship, of course that person would want to bring over his or her family who are residing in another country. So that is, we want to be reunited with our families, so we want to bring them over here. So that's how we basically define petitioner and beneficiaries, or beneficiary if there's only one. Okay. Now, there are actually or all family-based immigration, or immigrants, sorry, all family-based immigrants fall into one of two major categories. All right, we mentioned this a while ago. The first one is, of course, the immediate relative, and the other one is family preference categories. Okay. For immediate relative, there are unlimited number of visas available to immediate relatives. This means that immigrants in this category do not have to wait in line for a visa number to become available for them to immigrate. So unlike family preference categories, they have to wait. There's a certain number of years to wait. In addition to immediate relative, in addition to that, what I've already mentioned, certain bars to adjustment do not apply to the immediate relative category, which significantly benefits those people who are intending immigrant who overstays a visa or works in the United States without authorization. What am I talking about here? For example, a tourist, a person who's a holder of a tourist visa, overstayed his or her visa. So if that person marries a U.S. citizen, that person can still adjust his or her status, even though he or she overstayed his visa. For some other categories, if they overstay their visas, they will not be allowed to adjust his status anymore. So that's why it's very important to understand what visa are you holding, and if let's say, for example, you overstayed it, will you still be able to adjust your status later on? An immediate relative is one of them that even if you overstayed your visa, you can still adjust your status and become citizens later on. But for other categories, you might not be able to do that. That benefit may not apply to you if you're not an immediate relative. So the immediate relative categories are for a select group of relationship with a U.S. citizen. And who are the immediate relative under this category? You can see there on your screen. We have spouse of a U.S. citizen. We have the unmarried child who is under 21 years of age of a U.S. citizen. Orphan, adopted abroad by a U.S. citizen. Orphan to be adopted in the United States by a U.S. citizen. And a parent of a U.S. citizen who is at least 21 years of age. So our parents, my mom, my mother, for example, is my immediate relative, and so she can come here. She can come over here based on my petition, and she doesn't have to wait for a certain number of years. So that's the good thing about immediate relative. Now, so if the person did not or do not fit in one of these categories, that person may fit into the family preference categories, which is on the right side of your screen. The family preference categories include all other qualifying family relationships with a U.S. citizen who are not listed in the immediate relative, and some specified relationship with a lawful permanent resident or LPR as well. So who are included in the family preference categories? We have the unmarried adult sons and daughters, ages 21 or above. So they're your children, but they're over 21 years old. Or spouses and unmarried children under age 21 of permanent residence. So even if it's your spouse or your unmarried children who is below 21 years old, but you are an LPR or legal permanent resident, then your family member, this family member will fall under family preference category. Also, married sons and daughters of any age of a permanent residence, of U.S. citizens, and brothers and sisters of adult U.S. citizens. How is this category different from the immediate relative? Well, for this category, the family preference category, immigrants are the ones who must wait for a visa to become available. So they have to wait in the country where they are trying to immigrate from, which means that a legal permanent resident may not seek a green card for his own spouse until the priority date becomes current. Essentially, what this means is that the green card filing cannot be immediate. You have to wait until it becomes current, or the priority date becomes current. So that's how it works under family preference category. So it's faster if it's immediate relative than a family preference category. Okay. All right, okay, my screen doesn't want to move. Okay, I guess this one is gonna work. Okay, here's the technicality part. Let me stop sharing for a little while because it's not allowing me to change my screen. Okay. And let me share again. It's nice to see each other's faces again from time to time. Okay. All right. So here we go. Okay. I think I already mentioned this. Yeah, we're done with this one. All right, let's go to the next slide. So remember I mentioned to you earlier about the definition of spouse. Let's look at the definition of spouse under immigration and family law. So there you go. Under immigration, spousal relationship is recognized if when there is a marriage ceremony and marriage certificate. So you're considered a spouse. And why is this important? Because remember the immediate relative petition and the family preference petition. So we need to know who is considered as a spouse under immigration law. So again, when there is a marriage ceremony and marriage certificate. And the second one is good faith, which means that the marriage was entered into in good faith and with the intent to share a life together. So good faith and the intent are very important concept there, because those are the things that you need to prove to the USCIS officer during the interview and when you submit your petition. All right, the other important information about spousal relationship is cohabitation and commingling. So cohabiting and commingling of funds. So when you file a petition for your spouse, they will look into whether did you commingle your funds, because it makes sense. If you're husband and wife, definitely for sure, your funds are commingled because you're sharing your resources. And of course, the other is cohabitation. You should be living together, because how can you be husband and wife if you are living separately? Well, of course, there are some exceptions to that, but generally, you have to prove cohabitation and commingling of your funds. Now, the other recognized marriages, this was controversial before, but now it's already there. It's the same-sex marriages. So that means same-sex marriages are already recognized here for purposes of immigration. Also marriages from abroad and also common law marriages. When we say common law marriages, these are, couples who are living together and declaring themselves out in the public as husband and wife. Without the benefit of a marriage ceremony or marriage certificate. They are under immigration law, they're considered spouses. So yes, they can petition each other, or the US citizen spouse can petition the non-US citizen spouse. Now, but for common law marriages, it's not enough to just declare you are common law spouses, but you have to do something more than that. You have to have your common law marriage be declared as common law in a court proceeding. Okay, so it's not enough that you just, because I know some people who ask me about it. They've been living together for 30 years and they never went to court to have their marriage declared. So that is lacking. They need to do that in order for them to benefit from under immigration law. Now the other one, the one at the bottom, it says not recognized. Of course, these are marriages that are not considered spousal relationship under immigration law. For example, polygamous marriages, because polygamous marriages actually violate our public policy, and others violation of strong public policy of the state of residence of the couple. Let's say, for example, in the Philippines, if polygamous marriages are not allowed in Philippines, then it will not be recognized here as well in the United States. The other one is proxy marriages. If you haven't heard of that, it means that a US citizen is marrying a non-US citizen, and the US citizen is staying here in the US, but somebody else is stepping into his shoes as the groom, if that's the male spouse or soon-to-be spouse. Somebody is stepping into his shoes, representing him during that marriage. Well, that is not allowed in the Philippines. So if it's not allowed in the Philippines, it's not going to be allowed here in the United States as well. relationship where one party is not present during the marriage, like proxy marriages, is not recognized according to the immigration law unless the marriage has been consummated. So there is that a little requirement there. But the question is, how can a marriage be consummated if the other spouse is in the United States? So that's not possible. There's no virtual, not yet. There's no virtual consummation yet, as far as I know. You let me know if that is existing somewhere in other parts of the world. But as far as I know, there's no such thing as virtual consummation. So that is good to know also. Now, in contrast, under family law, when we say family law, in Texas, of course, I'm talking about family law in Texas, the definition of spousal relationship is based on ceremonial marriages. So there must be a marriage ceremony and a valid marriage certificate. But Texas also recognizes informal marriages or common law marriages, just like I've mentioned under immigration law there. But, like I have mentioned a while ago, in practice, the declaration of informal marriages must be filed to show a common law marriage. So in Texas, there is no required number of years. So even if you just cohabited within, I don't know, maybe 1 week, but you declare yourself as husband and wife out in the public, and you're living as husband and wife, and you're cohabiting and your funds are commingled, then you can declare yourself as common law spouses, but you have to go to court to have it declared. So yeah, that's one thing that a lot of common law marriages are asking is, how long do we have to stay together in order for us to be declared common law married? Here in Texas, there is no specific number of years. So yeah, okay. All right, so let's go. Now, there is one important thing here about immigration and marriages. And I'm talking about fraudulent marriages, okay? Marriages or divorces as well, entered into for the sole purpose of evading immigration law, are not valid for immigration purposes. And USCIS takes this extremely seriously. The Immigration and Nationality Act, which is the law that governs most of the immigration laws and policies, clearly states that any benefit applied through fraudulent marriage will be denied. And even if they already granted you your, let's say, for example, green card, and later on we're able to adjust your status and obtain your green cards and obtain your citizenship. If it's a marriage fraud, they can always go back and cancel even your, citizenship. But of course, there's a proceeding to that. It's not automatic. There's a proceeding in that matter, but they can actually do that. Because here the USCIS will consider the following factors there on your screen as triggering marriage fraud. So if it raised the red flag there, they will scrutinize your application, and they will conduct further inquiry or investigation as to whether the marriage was fraudulent for immigration purposes. So those are the red flags. So they look at the disparity of age. So how far is your age from each other? Like if you're, let's say, 19 years old and you're marrying 72 years old, so that's a red flag there. I'm not saying you cannot, but I'm saying it's a red flag. They will scrutinize your application. The other red flag is inability of petitioner and beneficiary to speak each other's languages, because it makes sense. How can you establish a relationship if you don't understand each other? You will not have interpreter all the time, especially if you're already sharing one room, and I don't think interpreters will be, and it's a good idea inside the same room with the two of you. So yeah, those are, that is a red flag to them. The other red flag is when family or friends are unaware of your marriage. So like, for example, your mother didn't know you got married. So those are red flags. Or during the interview, they ask what is the name of your mother-in-law, and you can't even say the name, then that's a red flag. And I remember one time, one of my clients were asked, what is the birthday of your mother-in-law? And he was like, he knows it, but he was mental block, I guess, at that time, and he couldn't remember. But the USS will sometimes, it depends on the interviewer. Sometimes they are very flexible, and sometimes they're also by the book. So really, it depends on the discretion of the interviewer. But in that case, the client was allowed to adjust his status. So yeah. The other red flag is the beneficiary is a friend of the family. Or you like a family friend, and I know somebody like a family friend who is who married the family member, and it was a red flag because you're a friend of the family. So how can you develop a relationship with the petitioner? All right, so that's a red flag. The other red flag is when the marriage is arranged by a third party, and when there is no cohabitation since marriage. That means that you were married, you were both here in the United States, but you never lived together. And sometimes they do special surprise visit. If there's a red flag, they might visit you in your in the address that you have given them. Because like I said, they will scrutinize your application if one of these red flags is present in your application. Yeah. Okay. So now let's have a quick brain check, and I always do this. If you're a FAATx member, you know me. I always ask questions just to check if you're still there and you're listening. And sometimes it also helps us remember what we talk about at least. So here's a question. Are there visa quotas for immediate relative category? Raise your hand and say yes. Don't raise your hand and say no. Are there visa quotas for immediate relative category? The answer is no. Remember what I have mentioned a while ago, that they don't have to wait for a certain number of years. It's always current for them. So when you file a petition for your parent, and parent is an immediate relative, and you are a U.S. citizen, then your parent can come over here in about, well, I'm not saying absolute, but from given the pandemic situation, maybe 12 to 16 months, somewhere there. And I see a hand here. Is that a question? I see a hand. Who is this? I'm sorry, I can't see the name. It's all black in my screen. So if you have any questions, just type it in the chat box and we will look into that later. Or I don't know if you're voting for yes or a no. Okay, so we're moving on. All right, so we're done with our first learning objectives. First learning objective, which is understand why family law is relevant to immigration law. Like I said, many people immigrating or people who obtain lawful permanent residence are coming from the category of immediate family relatives, immediate relative, and the other category is family preference category. All right, so let's go to the next part. And we're going to talk about immigration and divorce. So what is the intersection of immigration and divorce law here in Texas? Okay. So here's the first question I want to ask. How does immigration status affect divorce cases in Texas? Does it have, of course, if we say divorce, it's terminating a valid marriage, all right? In Texas, whether you or your spouse wants a divorce, ultimately, either one of you will be able to get it. You cannot stop it. If one of you wants a divorce, you cannot stop that because you cannot force somebody to stay in the marriage, right? So it will be able, that person will be able to get the divorce that he or she is wanting to. Now, if a spouse opposes, a divorce that can make things more difficult in terms of immigration, because then it takes longer. And I mean, not just immigration, but in the divorce proceeding itself, if the other one is not in agreement to obtain a divorce, then the process will take longer and of course will cost you more. However, in Texas, contesting a divorce does not stop the process. It will still continue. Like I said, you will be able to get that divorce. It may only delay the process. Now, remember that a spouse cannot force you to stay in a marriage. So how does immigration status affect divorce case in Texas? The state of Texas and Texas Family Code do not require U.S. citizenship for a couple to file a divorce. So even if you are a non-immigrant in the United States, you can still get a divorce decree here in Texas, or pursue a custody case for your child. Like I said, U.S. citizenship is not required by the court. However, Texas requires that a person seeking divorce here in Texas must show that he or she resided in Texas for 6 months. All right, that's actually not 60-day period, but 6 months. That's a correction there. 6-month period in Texas. So 6 months living in Texas, and you're living in that county for 90 days prior to filing of your divorce case. Yes, so that's a requirement. 6-month period in Texas and 90-day period in that county. Like for example, if you're filing a divorce case in Harris County, you should be a resident of Harris for 90 days prior to filing your petition for divorce. That's the only requirement. So if you are here on a tourist visa, I'm not sure if you can qualify for this, because usually they'll grant you only 6 months unless you ask for extension and your extension is granted. So then you can file a petition for divorce here because of the required 6-month period living in Texas. So yeah, so that's the other important information there. Now, since here Texas allows a no fault divorce, so you can basically obtain divorce for simple reason of insupportability, which means that your petition alleges insupportability, which is defined as a discord or conflict of personalities that destroys. Can I ask, please mute your microphone? Could you please, because I can't mute your microphone.
Yeah, Miss Ganda, mag-mute ka dyan.
Nakamute ako ah.
Hindi ka nakamute. Yan, ngayon pa lang. Thank you.
Because I couldn't see it here, it's not muted. So thank you. And it happens, so that's okay. Like I said, mere ground of insupportability here in Texas, you can obtain a divorce decree. When we say insupportability, you can no longer take each other. You don't want to see each other every day. You can no longer fix that relationship. Actually, the exact wordings under the law is the discord or conflict of personalities that destroys the legitimate ends of the marriage and prevents any reasonable expectation of reconciliation. So if you think you will no longer be able to reconcile, then yeah, you can get divorced here in Texas. Now, going back to our question regarding the effect of divorce on the immigration status of the non-citizen spouse, divorce affects non-citizens in many ways, and it could greatly alter the ability of that spouse to stay in the United States. Okay, and so we're going to look at that one here in the next slides. For example, individuals with pending permanent resident application or petition, or you are still filing a conditional permanent resident application. So that's within a two-year period from your marriage. If you get divorced during the first 2 years from getting married, then that could greatly affect your petition. I'm not saying it's going to be denied automatically, but you have to do something more. You have to prove more than just waiting for that petition to be decided by the USCIS. The other one is individuals who are dependents on non-immigrant visas and individuals who have their spouse as their qualifying relative for waivers, something like that. So let's briefly look at the conditional residence here. So when I say if you're adjusting your status based on marriage, okay, the first 2 years is very critical. A person obtains conditional permanent status if their marriage was less than 2 years old on the day they obtain it. The CPR, or the conditional permanent resident, receives a card valid only for 2 years. So after 2 years or before the expiration of the 2-year period, the spouse, the non-US citizen spouse, must apply for removal of the condition and to become a full permanent resident. Now, if the couple will need to file the correct form here, of course, and jointly show that the marriage is still ongoing. When the non-citizen spouse filed an application to remove the condition in his or in her conditional green card, they have to file jointly, and they must prove that they are still in a relationship. They're still happily married. So, so if they divorce during that time, then they will need to do more than just submitting those documents, because then how can you prove that you're happily married? How are you adjusting your status and to permanent residence if it's based on the marriage that is no longer existing? So that's the challenge there if you get divorced during the 2-year period from getting married. Okay, so the question is not whether a couple currently resides together, but whether they intended to establish a life together as husband and wife at the time they were married. That's why it's important to show that they really are living together as husband and wife, because otherwise then that could be a red flag and it will trigger strict scrutiny on the part of the USCIS officer, because that will be a red flag to them if they're no longer living together or if there's a divorce case pending. So that's why the first 2-year period is very crucial. Okay, and yeah, so that's what I'm trying to explain a while ago when the divorce happened before the 2nd anniversary of their wedding date. So that first 2-year period. Now, as the non-US citizen spouse, he or she may have to deal with additional hardships in trying to stay in the United States because of possible loss of permanent resident status. Now, if the couple divorces before the 2nd anniversary of their wedding date, then the illegally residing spouse is subject to deportation. Now, why illegally residing spouse? Let's say, for example, the spouse was here originally on a tourist visa and overstayed the visa, and then married a US citizen. All right, so that marriage, but by the filing of the petition for the spouse beneficiary, the non-US citizen, there will be no deportation proceeding that will filed against that spouse, although he or she has already overstayed her or his visa. But if they get divorced within that 2-year period, then that could trigger a removal or deportation proceeding against that spouse, because remember, she already overstayed her visa at that time. So that's the hardship there. Now, although a Texas divorce court will not contact the USCIS about your immigration status, that will not stop any interested person or even the soon-to-be ex-spouse from doing so. So when you file your petition for divorce in a family court in Texas, that family court will not report that petition to the USCIS. But anybody can inform the USCIS, and that will trigger that deportation proceeding against that spouse. So it's really very crucial, that point. Well, of course, like I have mentioned a while ago, there are some exceptions to the said rule, which need to be discussed with the assistance of your immigration attorney later on based on your case, because it's a case-to-case basis. Now, a soon-to-be divorcing spouse needs to prove that. In this case, where there's already divorce, and I'm talking about the exceptions. I have mentioned intention. I've mentioned there when there is whether there are children involved or hardship or presence of violence, then you can probably obtain a waiver in that matter. Okay, so somebody is raising hand. Do you have any question? Because I will address question at the end of the presentation. Or you can type your question in the chat box and I will read that one later on. Okay, all right, thank you. All right, so as I've mentioned, the soon-to-be divorcing spouse needs to prove that the marriage was entered into good faith in order for you to obtain an exception to that rule. And that the couple live together as husband and wife. You have to prove that. Now, the other consideration is when the couple owned property together. So you have to prove that you purchased property together or that you had children together. Those are very important aspect there to prove that your relationship is real and to obtain the waiver for that, the waiver from that. Okay. All right, continuing. Also showing that the immigrant should he or be deported would also face financial I'm sorry, could you please mute your microphone? All right, thank you. Okay, so what I was saying here, okay, I'm going to talk about scenarios later on. So in order for you to obtain exceptions to that rule, remember I told you that if you obtain a divorce during the first 2-year period, that it will trigger a deportation proceeding against the non-immigrant spouse. There are exceptions, and those are things that I am actually discussing right now. And other than those that I've already mentioned, the spouse should also, the spouse about to be deported must show extreme hardship during that time, and that the immigrant was the victim of abuse or mistreatment by their soon-to-be ex-spouse. So those are the important information that the non-US citizen spouse would have to prove in order to obtain that waiver and not be in a deportation proceeding. Okay, and these exceptions will likely or most likely allow the non-citizen spouse to remain in the country. I'm not saying this is absolute, but it may allow, depending on the amount of evidence that you are going to present to the USCIS and how convincing your evidences are, depends on those basis if the USCIS will allow you a waiver or not, or allow you to remain in the country. So here's a scenario that I'd like to share. Now, the first one is a scenario about marriage adjustment of status, and I'm going to discuss this too in separate slides. Okay, we still have time. All right, so the first scenario is about marriage adjustment of status, where the spouses are not living together anymore at the time of their interview, and the spouse lied about it to the USCIS. And the other scenario is marriage fraud. So let's look at the first scenario here. So here, here the person or the couple has already separated during the interview. So the interview is for adjustment of status. So now a person received a notice of intent here to rescind his status by USCIS because he was not living together with his wife at the time of the adjustment of status interview, and he lied about their living arrangement to the officer. So what happened here is that they already been interviewed. They pretended that they were living together during the interview. And so that's why there's the lying part to the USCIS interviewer at that time. Now, what did the court say here? Adjustment can still be granted, or as long as the marriage was not a sham and had not been terminated, adjustment can still be granted if the parties have separated and no longer they no longer have a viable marriage. They were still allowed to adjust. And the reason why I say this is because in one case, the Bureau of Immigration Appeal held that a visa petition could be approved even though the parties had separated and the marriage was no longer viable, as long as the marriage was bona fide at inception. It's valid at the beginning of the relationship, and it's not a fraud and had not been terminated, and not whether the party were living together at the time of the adjustment or whether the marriage was even viable at that point. So the USCIS officer considered the fact that the marriage was valid in the beginning. The USCIS did not believe that the marriage was fraud, so that's why they were still granted the green card. I mean, the non-US citizen spouse was allowed to adjust his status. But as to the lying or misrepresentation during the interview, the BIA held in one case that adjustment cannot be rescinded based on the charge that he had materially misrepresented his living arrangements with his wife. So in other words, he was not punished for lying during the interview. That is because they were able to prove that the marriage was not a fraud. So that's very important there. So like I said, it depends on the situation. It depends on your case. It depends also on the discretion of the officer who is interviewing you at that time. Okay, so that's a good thing for that person. Now for the second scenario, this one is about fraud marriage, which is here, marriage fraud as well as immigration fraud are serious issues in the eyes of those of the USCIS. And I have to mention this many, many times because really they take it seriously. And so in one case here, a couple falsely claimed that they were married in good faith. So there was really no valid marriage in the beginning. And they pretended they were married. The truth is their marriage was a fraud and was entered into solely for immigration purposes. They got married in 2007 and they got divorced in 2009. The marriage was never consummated. And also during, not during the interview, but after a case was filed against them, the US citizen spouse admitted that he was paid about $7,000 for participating in the marriage fraud scheme. So in this case, the maximum potential penalty for the US citizen spouse is 10 years imprisonment or a $500,000 fine and supervised release for a period of 6 years. So this is too much. The purpose of this penalty is to discourage people to enter into marriage fraud. So yeah, that's a serious case there. Okay, so brain check again. Let's see if you're still awake. Question: are common law marriages considered marriage for immigration purposes? Yes or no? Raise your hand and say yes, and don't raise your hand and say no. Are common law marriages considered marriage for immigration purposes? We said yes. All right. But immigration, under immigration law, they have to prove that they have, of course, the marriage is a common law marriage. They consummated the marriage, and of course, they have to declare that they have to go to court and declare their common law marriage. Yeah. So there's additional step for that. Okay, so now let's go to immigration and annulment, because annulment is definitely different from divorce. Okay, here we go. Immigration, all right. All right, so an annulment of marriage in Texas is when the marriage is actually fraud in the not valid in the very beginning. So really, like, there's no valid marriage to speak of. So that you can declare your marriage annulled. Okay. there's okay, so an annulment of a marriage in Texas that had previously revoked in the approval of an immigration benefit could lead to revocation of resident status and revocation of non-immigrant visa. So it's very important if you're filing divorce or are filing annulment, because if it's annulment, you're saying that the marriage was not valid from the very beginning. So what is the difference between a divorce and an annulment? So let's look at that in the next slide. Okay, I'm going to talk about that in a little bit. So in a divorce proceeding, a court recognizes that there was a valid marriage and that the marriage is now ended, right? There was a valid marriage and you're ending the marriage. In an annulment proceeding, a court recognized there was not a valid marriage from the beginning, and it will be as if the marriage never existed legally. So an annulment is likely to either complicate or cancel your application process. Now, if you haven't yet finished applying for an immigrant visa or green card and you obtain annulment, if your US spouse has started the process for you by filing a petition for annulment, and even if that petition has been approved, you yourself have no rights to reside in the US, much less to apply for a green card on the basis of that marriage, because basically the marriage did not exist. Although in theory, you still have many steps to do, such of course, filing your own application materials, attending interview. In the course of this, you'd be expected to prove the marriage is ongoing and your spouse continues to be willing and able to sponsor you financially. So how can you prove that if that other spouse is saying there's no valid marriage? So yeah. If the interview is also held in the United States, then you and your husband will have to are expected to attend interview. Of course, the other one will no longer attend the interview. So that'll be extremely hard for you to proceed with the process. Now, the purpose of family-based green cards is to promote family unity. And of course, after an annulment, the immigration law figures there's no family in such case to unify. So that's why it will result to revocation of your status, resident status, and also non-immigrant visa. Now, of course, if you did receive conditional residence, it's possible to go forward. Well, I mean, if you receive conditional US residence already, unless you had already been married for 2 years or more when you applied for the green card, then you will have received conditional residence status, which is essentially a green card for that purpose, but will expire in 2 years, unless you prove that you deserve a permanent green card. So let's say, for example, you're issued a green card already and your spouse filed an annulment case. So if you did receive your conditional residence, it's possible still to go forward toward a permanent green card even after the annulment. However, you will need to request for a waiver of the usual, and submit the usual requirement that you and your US citizen spouse, of course, jointly filed a petition in the beginning and asking the court to convert from conditional to permanent residence. And in order for you to do that, you must have to prove that the marriage was bona fide to begin with, which is going to be hard for you because you already declared the marriage is not valid in the beginning. So how can you prove that? That's really hard to prove. And also, and it was that the marriage was valid in the beginning. It was entered in good faith and was terminated only through annulment. So that will be very hard for you to prove. You'll need to provide documents, of course, for the last 2 years of your marriage that the marriage was a real thing. So, and of course, the other spouse will not help you obtain that because he's already declaring or she's already declaring there's no marriage. So that's the thing about annulment. Okay, so let's look at annulment in real cases. Here, this is the case of Montenegro versus Avila. This was the case decided in 2012. Here, The El Paso Court of Appeals has affirmed, or declared that the marriage is has affirmed the annulment of marriage, holding that the evidence presented during the hearing supported the trial court's finding that the husband induced the wife to marry him for the sole purpose of obtaining legal resident status in the U.S. Now, according to the facts, the trio of facts, the trio of facts was the sole judge of the credibility, of course, of the witnesses. So what does it say in the facts? The trial court, according to the trial court, could reasonably have determined that the husband's conduct before and during the marriage constituted fraud to induce the wife to marry him and to stay in the marriage until he obtained permanent legal residence, and that the husband masked his true intent by making false promises about marriage and family, stated by the court. Actually, I have seen this happening many times, the inducement. And usually it happens when the age disparity is really big, like the US citizen is way, way older than the non-US citizen. And there's a possibility of inducement there. Now, this is the case of Montenegro versus Avila. In contrast, here in the next case, the case of Desta versus, I don't know how to pronounce this, Anyaha. Sorry if I mispronounced it. It's the same last name. Help me out here. Anyaha. Okay. Anyawa. I tried my best. Okay. So here it's the opposite of the case of Montenegro, because here the wife induced the husband to marry her for the sole purposes of obtaining legal residence status in the US. The other case, it was the husband who induced the wife. So in this case, the Dallas Court of Appeals, this is in Dallas, so the Dallas Court of Appeals has affirmed the annulment of marriage, holding that the evidence supported the trial court's finding that the wife induced the husband to marry her for the sole purpose of obtaining legal resident status in the US. So that's why, of course, it was revoked. The court revoked her status in this case. All right, so there, brain check. You still awake? Are you still with me? So is it true that annulment of marriage in Texas could lead to revocation of your resident status? Yes or no? Yes, raise your hand. No, don't raise your hand. The answer is yes. Yay, you're passing this. 3 out of 3 already. Good. Okay, so we're still awake. You're still with me. All right, we're almost there. Now this is immigration and family violence. Okay, let's stop sharing here. I just want to see the face of everybody to refresh our memory that, hey, we're here, we exist. Hello. And that I'm not talking to the computer, that I'm talking to real people.
Hello.
Say yes. Yeah. Unmute yourself so you can speak. Say, hi, I'm from somewhere. All right. So,
Thank you for your time. This is Leah.
hello, it's Leah. Thank you. Okay, so that's our little break there. You know, our brain can only take, I can only concentrate for how long? 20 minutes? And I know that because when I was teaching, I will ask my student, did you understand what I said? Yes. But when I give them like a question, they have no idea what I talk about. So, yep. So from time to time, we need to check each other. Are we still okay? We're still breathing. We're still smiling, and say something so at least you can, you know, exercise your vocal cord. Okay. So let's continue. I'm going to start sharing again. All right. There we go. So here we're going to talk about immigration and family violence, and this is happening shockingly. I have some clients who are actually Filipinos as well, and they're involved in family violence. At first, I couldn't believe, like, really, your husband, your real wife? And when I say family violence, it's not only the husband I'm talking about who is the abuser, but it could also be the wife, you know, either way. it could happen. So it's not just the husband. Okay, so let's go to the next slide. And my slide there. Okay, here we go. Immigration and family violence. If the spouse here is a foreign national who is a survivor of domestic violence and who has previously resided or is residing with the abuser, means the husband or the wife. As an attorney, I always inquire more than just the regular information that we ask during intake, because it is important for me to know whether there is an application pending for an immigration benefit, in addition to considering the foreign nationals case in light of the Violence Against Women Act of 1994, which is also known as VAWA. And the reason why I say this is because the family violence could greatly affect the relationship. And there could be a separation of husband and wife, and if there is a family violence related involved, then we have to separately discuss that one from the divorce and the annulment, because there's a special case there's a special benefit under immigration law for victims of violence. And so that's what I want to talk about in the next slide. Okay, so we said that if there is a violence involved, family violence involved, and the application of the Violence Against Women Act and U visa, we said these are possible lifesaver, really. Lifesaver, not only literally speaking, saving the life of the person, but also the immigration status of that person, of the abusive spouse. Okay, so in the United States, we have the so-called Violence Against Women Act of 1994. This section of the law actually, that's the VAWA. You probably will hear more often the word VAWA, shortcut for Violence Against Women Act of 1994. This section of the law enables qualified abuse fiancés and spouse or parents and children of United States citizen and even legal permanent residents to apply for a green card in a manner that removes the abuse from the picture. So they can obtain green card without the husband or the wife, whoever is the abuser. So what I tell my clients, you do not have to stay in the marriage if you're thinking only about your immigration status, because through VAWA, you may be able to obtain green cards and you do not need to stay in that marriage. So that is very important. The abuse survivor or the spouse may be able to self-petition for a green card if he or she can demonstrate that the marriage ended in divorce in the past 2 years because of abuse, okay? Or because the petitioner was a bigamist, or the abuser lost his or her immigration status because of domestic violence, or his or her spouse died within the past 2 years. So under this, you can self-petition. Now, the abuse survivor must demonstrate, of course, that he or she is a person of good moral character who during the marriage was battered or subject to extreme cruelty by the green card holder or US citizen or LPR spouse or parent. Now, if all these criteria I've mentioned are met, then the abuse survivor may get to remain in the United States as a green card holder. And I particularly remember one of my case that involves violence against, women. It's a domestic violence, and I was very happy to finally, when I received her green card, I was very happy because I know that that person can continue living in the United States and move on with her life, because it was not her fault for being subjected to violence like that by the US citizen spouse. And I feel so bad for all the other Filipinos who were victimized of abuse. but didn't survive. I'm particularly talking about the cases that happened in Dallas, Texas. If you remember that, the Filipino spouse was murdered, killed, and I think she was put in a basement in a freezer. That was very disheartening. So that's why for me, I have a special heart for this kind of cases, because it involves really life. Because here, there's a lot of people missing, and if they are missing, it's hard to find them. So what if all of a sudden my client didn't stop calling, and I don't know how to reach out for that person, because that person is not living close by me, is not in here in Houston. So what will I do? It's very scary. So each day matters in that case, really. Now, one note regarding VAWA, an application can be filed on behalf of an abused common law spouse also, an abused spouse who is male, and it can also be filed, of course, on behalf of abused children under age 21 or abused parents. So it's not only, VAWA is not only for the abused wife or, abused husband. And even if, and it's also available even if in case of common law marriages. Now for U visas were established in the year 2000, as a result of the Victims of Trafficking and Violence Protection Act. This visa is for person who have suffered substantial physical or mental abuse as a result of having been a victim of criminal activity. This application must be signed by the law enforcement agency conducting the investigation. So I can pretty much talk about U visa and T visa. I didn't involve T visa here because I'm particularly zoning into to anything related with family law. So U visa, but of course, trafficking could also be a case related to family law. Like for example, you're holding that your wife like a prisoner in your house, not allowed to go out, not allowed to travel, and many other instances of trafficking. Then T visa is also available for the victim. Now, domestic violence is a specifically enumerated crime on the list of criminal activities, so as are incest, sexual exploitation, rape, torture, and trafficking. So it's not just basically hitting your husband or your wife, but it also involves any of this that I have mentioned in order for you to qualify for your visa. In addition, trafficking victims may bring a civil action against the perpetrator in the United States District Court and may also seek attorney's fees. And not a lot of people know this. So they think they don't have victims of trafficking and family violence. They think that they have no way out because they are being threatened by the husband, by the abuser spouse, about their immigration status, or that they will be deported, that they will be put in jail. So a lot of threats like that. Sometimes ordinary people like us will think, well, why would he or she stay in the marriage? She's or he is already being hit, hurt, torture. But if you're not in that situation, it's really hard to speak for them because you don't know what they're going through. They're psychologically also being battered. So please take note of that. It's not just one-time hurting, one-time violence, but it's an ongoing violence that's happening every day. So that will change a person's perception or mind or state of mind. So it's hard to understand him if you have not been in that situation. So anyway, the U visa category allows the entrance of the family of a U visa holder without that person having to show extreme hardship or requiring an investigation. So maybe all they need to do is to involve the officer, the law enforcement officers, because the law enforcement officers will issue a certification that they are victims of violence, family violence, and they can use that piece of paper to apply for a visa, a U visa. And then that U visa or T visa will later on allow them to change or adjust the status and become permanent residents. And then later on, after qualifying or after proving that they have obtained all, or they have all the qualifications to apply for naturalization, then they can also naturalize. So it's a path for citizenship, the U visa and the T visa. Okay, so yep, that's for our visas. And these are the differences between the VAWA and the U visa. So under VAWA, it allows spouses or children up to 21 years old abused by the US citizen or LPR, a spouse or parent, to self-petition for adjustment of status green card. For U visa, the victims, there is no qualification for you to prove extreme hardship. All you need to do is to show that you have been certified by the law enforcement officer that you are a victim of a domestic violence or a crime for that matter. Then you can already file or self-petition for a green card. Okay, brain check again. VAWA means Violence Against Women and Children Act of 1994, true or false? Raise your hand if you say it's true. Don't raise your hand if you say false. You're right, it's true. That's the meaning of VAWA. Okay. All right, so we're done with our second learning objective, which is about the effect of divorce, annulment, and family violence on your immigration status. I hope that you're learning something from me. Maybe sometimes I'm speaking too fast. I'm trying my best not to, because this is a webinar, this is online, and I understand sometimes internet or Wi-Fi plays important role in the delivery of the message. So we're down to related immigration developments. Okay. There we go. The first one I want to share is, well, if you are a veteran, this is good news for you if you're living overseas, because we know that a lot of people are, vacationing, and then because of the pandemic, they couldn't go back, and they want to naturalize, but how are they going to do that if they are outside the US? Well, as of May 28, 2021, they can already file application for naturalization to naturalize, even if they are currently residing outside the United States. So typically, we can file application for naturalization if you are here in the United States, physically present in the United States. But because of this, they're allowing veterans to file application and naturalize even though they are outside the country. Now, only current service members and eligible family members may complete the naturalization process overseas via secure video in partnership with the Department of Defense at a designated facility. So they have a strict requirement of the secure video, and you have to secure that in partnership with the Department of Defense at designated facility where you are located, let's say, for example, in the Philippines. Now, these current service members and eligible family members are not required to be present in the United States for any part of the naturalization process because of the provision of specific immigration law. Okay, so if you're veterans, yes, you can already naturalize even though you are outside the US. All right, the other immigration updates I'd like to share is, USCIS reverts to the 2008 version of the naturalization civics test. Now, if you are, let's say, for example, last year trying to naturalize, and you filed your application somewhere in December, you're like in a limbo. Am I going to be covered by the 2008 version of the Naturalization Civics Test Act or the new policy issued by the Trump administration? So what's the difference here? The applicants who filed their application for naturalization on or after December 1st, 2020, and before March 1st, 2021, will likely have been studying for 2020 tests. Therefore, the USCIS said, you will give this applicants the option to take either the 2020 civics test which will require the applicant to answer 20 questions and must get at least 12 correct answers to pass the test. Now, under the 2008 version, they're only required to answer 10 questions. And if they get 6 correct answers, then they pass the test. So, 20 questions versus 10 questions. The good thing about this is, let's say, for example, you answered all the 6 questions already, then the officer will no longer ask you the remaining questions. So if you prepared for your interview, then you don't have to, worry about the 10 questions for now. So because we're back to 10 questions, and you only need 6 questions to pass. So that's the good news, right? Because a lot of people are asking me, is it hard? Is the question hard? No, they give you, they have this pre-made questions that you have to review. So you just have to read it over and over again. And there are some YouTube videos actually that you can watch and as a review for that matter, you can watch it over and over and over again. So if you're doing something, you're multitasking, you can listen to the video and you will remember. Anyway, there are actually 100 questions, and out of 100 questions, they will pick 10 questions, and then you need to answer at least 6 correct. So that's the civic test. Now, the other information here I'd like to share is if you already heard the vaccine passport, this is in relation to, of course, COVID pandemic, COVID-19. Well, the truth in vaccination bill, actually New York, this is in New York, they passed this truth in vaccination bill. The truth in vaccination bill is aimed at deterring individuals from lying about vaccination status and prevent medical professionals from falsifying COVID-19 vaccination records. So of course you can, for the righteous people who are trying to stay as good citizens, of course we're not gonna, we're scared to falsify any information in our vaccination card, right? But some people are doing that because some establishments, they require that you have to be vaccinated. You have to actually show your card in order for you to be able to enjoy the benefits of that establishment. And so because of that, some people are, forging or falsifying their cards to show that they're actually they're vaccinated. So what New York did, oh, it's still a bill, it's not yet passed. They issued this truth in vaccination. So here they recommend that if you're found guilty of counterfeiting your COVID-19 vaccine documentation and you are a non-medical professional, you would be charged with a Class A misdemeanor. But if you're a medical professional, then you would be charged with a Class E felony. So if you are a green card during that time, you don't want to be charged of any of this misdemeanor and felony. Now, well, it is anticipated that as more New Yorkers are vaccinated, the sports and entertainment venues, restaurants, and other businesses may require proof of vaccination. So that's why they're thinking that, okay, maybe some people will try to, falsify this document in order for them to benefit from those establishments. So that's why they're recommending this one. Of course, it's still a bill. It's not yet passed. So we'll see about that. That's something that's interesting to know. And I don't know if you're going to have one like that here in Texas. Okay, so we're done with our third learning objectives. Whew. Finally. And the good news about this, I don't have a brain check. So I can stop sharing now, I guess, so I can see your faces again, beautiful faces, smiling faces. That means you're still not bored. Thank you. Okay, so questions. Let's see if we have some questions here. Let's address them quickly. I'm going to look into our chat box and let's see what we have here. Let me read. Okay, hi everyone. I am not a cat. Oh, I already read that. How about this is from Connie. How about a permanent resident with ongoing citizenship application got divorced in the middle of the process? So here, I think since I don't have all the facts, so I'm just gonna to answer this based on what I have right now, the information that I have. So the person is a holder of a green card and in the process of filing an application for naturalization, right? And then a divorce happened. So I don't think the divorce will have any effect. Um, but it depends, okay? So let's say, for example, the person obtained the permanent green card or the permanent residence or the green card through marriage, then because if you obtain your green card through marriage, you can already adjust obtain or apply for naturalization after 3 years of getting your green card. But if it's not based on marriage, then you have to wait for the regular 5-year period before you can apply for naturalization. So in this case, if let's say, for example, it's within the first 3 years, right, of the marriage, from the issuance of the green card, and you file a divorce and there's a proceeding, if it's still a proceeding, it's not yet, there's no decree yet, then you might still be able to naturalize within a 3-year period because there's no decree yet. Basically, your divorce, your marriage is not yet terminated because there's the divorce proceeding is still pending. But if it's already past 3 years and you did not, so happen you did not, or you're too busy to file your application for naturalization and it's past 3 years, and now there's the other spouse filed a divorce already, and it's still pending. You can still, because the marriage is still existing, but if the marriage is already finalized, the divorce decree is already finalized, then you will have to wait for the regular 5-year period in order for you to file your application for naturalization, because now by then you are applying for naturalization not based on the marriage, but based on your green card, regular green card document in that matter. So, okay, now here's another one. There are a lot of do-it-yourself website. Why do I need to hire an attorney in filing my green card through my U.S. citizen wife? Okay, so I assume that this person is trying to self-file, self-petition, right? I'm not sure if, well, it says their green card, so basically they already got married and they're already applying for green card. So basically we're talking about Form I-130 in this matter, the petition for immediate relative, for a spouse, and maybe it's a package. There's also an adjustment of status with it. So I'm assuming that's the fact in this case. Well, yes, you're right. Like I have mentioned a while ago, you can always self-petition yourself because the forms are out there. It's available in the USCIS website. And there's a lot of YouTube videos, telling you what to do. Everything is in YouTube now. Actually, the best teacher right now is YouTube. And I also use YouTube for learning about stuff, like, for example, how to copy paste, how to screenshot in my computer. So everything is in YouTube, honestly. And even how to cook dinuguan. So I learned it from YouTube. So anyway, yeah, there's a lot of information out there. But if you're in a situation that your case is not a simple case and there's some complication, you don't want to do it yourself because you might jeopardize your application. And the reason why I'm saying is that some people, let me give you an example. One of the cases I handled, they self-petitioned themselves. So they filed their own petition. They are already in the process of waiting for the decision. And then they received this notice of intent to deny. And so now the couple, they were in panic because the wife overstayed her visa. So if the petition is denied, then she may be put into a deportation proceeding right away because the USCIS already have, they already have your record that you are there, that you are now overstaying, so they can put you in a deportation case right away. So then they came to see me, and I look at their information. And the other thing there was that they waited for a long time, and so it was so difficult to fix those mistake if you wait for a long time, or if you try to conceal some information. It's really hard. I mean, what can we do now on this on that part? We will try to fix it, but we may be successful, we may not be successful, but it is your life who's at stake. So in the first place, you would want to make sure that everything is okay, all the documents are good, because remember, the USCIS officer is using his or her discretion. So if it so happened that that your paper is being reviewed or processed by USCIS officers by the book, that USCIS officer may not issue a request for additional evidence to prove your relationship, but may deny your application outright. And so if that happens, you'll have to start all over again, and then you're going to be in stress, thinking that there might be a deportation case filed right away. So really, you can do it, but you take the risk. Do it, but make sure that your documentations and your evidence are complete. Even in like pictures. Oh, it's just a picture, because you have to show proof, right, of your relationship. So you submit pictures of your relationship, of your marriage. I know in one case, the USCIS denied the application just because of one picture. And because that picture, in that picture, the USCIS is like, okay, wait a minute, this is a red flag here. Why is it that in that picture they're separated and the wife doesn't look like she or he is, the wife is not happy? So things like that. Or why is the background like this? Where are they? Is this their house? It's so messy. So there's a lot of things like, oh, it looks like there's some kind of a violence happening. So things like that we might overlook as as regular person, like, okay, we just submit pictures, they're together in the picture. So you must be very careful in all the documents that you are submitting to the USCIS, because if there is a red flag, just one red flag, they will scrutinize your documentations, they will scrutinize your applications seriously, and it could cost you a lot, not just money, because they're going to forfeit your application, also a lot of sleepless nights, stress, and so on. So yeah. Okay, so I hope that I'm able to explain why. You can, I'm not saying you cannot, you can, but be very careful when you're doing it on your own. Okay, so is there any other question here? All right. I don't see, do you, okay. That's it, right? We can unmute. Hello, I want to hear your voices now. I don't know, I don't see any other questions, and I'm sorry we overstayed. I knew it's gonna be a long topic. It's really, there's so much information, so that's why I just tried my best to just cover as much as I could. But if we're gonna have a second one, then I'll try to focus on, let's say, for example, immigration and adoption, a specific topic. I guess it's more beneficial, but at least we have an overview of what's happening, or why is immigration related to family law. And the reason why I also talk about this, because as an attorney, immigration is a federal law. So basically I can provide immigration services to whoever, wherever you are situated here in the United States. But I should be very careful, because if it involves family issues, then I will probably need an attorney in that area to help me out with the family law aspect of that, because then I don't want to be advising the client of state law, because I'm not allowed. So by here in Texas, since I'm licensed here, I can very much, advise my client on whatever aspect of immigration and family law is involved in his or her case. So,
Aileen, I have a question.
yes.
I have a question.
Go ahead.
You adequately covered spouses. What about fiancés?
Oh, what specific? We can do a specific fiance visa later on if you want, but yeah, but I covered a part of it because of the the 2-year period. You come over here as a fiance. It's because you can get married here or outside the United States, right? If the non-US citizen is outside the United States, then you have to bring her or him over here through a fiance visa. Unless you want to go to the Philippines, let's say, for example, the fiance is in the Philippines, you get married there, then you come back here, then you can file a petition here already, a family-based petition already for your spouse who is outside the US. So it's different. It depends on where the non-US citizen spouse is located at that time. Because if the fiance visa is only for the purpose of bringing your fiance over here to give her a visa to come over here so you can get married here. But basically, you can go to the Philippines and marry there, or you can go to Japan or wherever you want to marry your fiance. And then come back to the United States and then file a petition, which is already the immediate relative petition. So then your spouse who's outside the country can come over here, not through a fiance visa, but through your petition already, as a spouse, your spousal petition. So
Thank you.
yeah. Okay. Sir Alex, you're not thinking of petitioning any fiance.
Oh, I'm
Sorry,
happily married, Aileen.
I'm joking.
I'm happily
I
married.
know. I met your wife. I went to your house. I'm just kidding. It could be a friend, right? So yeah.
Yeah,
But it's a
I
good
was
question. It's a
in
good
fact thinking
question.
about a friend of ours. Some of the guys here know this person also, and this happened so many years back, and he brought his fiance over. I just did not understand what the process was.
Yeah,
So
actually,
I just
they're
wanted to-
kind of confused about um why get a fiance visa, if the soon-to-be spouse has a tourist visa, because it's just a matter. The fiance visa is for that spouse or soon-to-be spouse to be able to come over here. So, like I said, you can use that visa to bring that spouse, the fiance here to get married, or go to that country and get married there, or go to another country. And because I know somebody who they're Filipino citizens, but they get married in the Filipino citizen and the U.S. citizen got married in Japan. So
Is a
it's their
fiance
preference.
visa easier to get than a tourist visa?
It depends on the situation. It depends on your documentation that you will submit to the USCIS. And it depends on the USCIS officer who's going to be interviewing or reviewing your application. Sometimes, well, you know that if you tourist visa, you have to prove that you're really going back to your country. So that's discretion. But for fiance visa, you have to prove that you have a relationship and that you intend to marry that person. So different, they have different requirements. So it depends on your evidence at the time you submitted your application. And like I said, it's discretionary. It's very subjective. So sometimes the officer is too strict. Sometimes the officer is too flexible. So really, those are the factors that we have no control. But what we can control, of course, is the part that we have to fill out the correct application form, submit the correct documentations and complete information. And of course, everything is authentic. Information, relationship is real, because it's hard to be involved in marriage fraud.
Yeah.
Yes. Okay.
Okay.
Well, thank you so much, Aileen, for doing this lecture, and we are always grateful to you and Orly for the help that you give FAATx.
And thank you for inviting me or having me again here. I always enjoy presenting to your group. You are a group of awesome people, very interested in a lot of things, wise people, very nice, very friendly. And also, I'd like to thank those who attended the webinar today. I might not know all of you, but thank you for sharing this evening with us. And if you have any question in mind later on related to my presentation, you can feel free to email me, or that's my email address there on the screen, or message me on Facebook. How else? Or go to our website and ask your question there. There is a place you can actually type your question. And if you have any other, if you have question about other aspects outside the my presentation, feel free also to send that message. And if you have a recommendation later on that you want me to talk about, so maybe we can consider that. So yeah, feel free to just message me.
Thank you.
Thank you.
All right, thank you.
Thank you.
Okay, so I'm gonna have to end this one. I know you have a meeting tonight.
Thank you so much.
Thank you, Tony.
You're welcome. And do you still have a meeting? Do you still have to stay for your meeting?
Attorney, after you log off, we will actually sign into our FAATx
Okay.
Zoom
All right,
account.
great.
But thank you so
All
much.
Thank you.
And I will tell Orly
Okay.
about it.
Okay, good night.
Okay, good night. Bye.
Bye-bye.
Thanks
Salamat.
again.
Thank you.